Sounds good.
All right, you guys, welcome to Surveys Demystified. In real estate, we know that our most important goal is to convey a clean and clear title. And yet, surveys are one of the hardest things to get clients to order because it's another expense, right? And they can be a little confusing. It seems like a sheet of paper that they could just look at on GIS, but it's really important that we understand if there's any encroachments or easements, if there's anything affecting impervious surface, and they can be a little hard to interpret. Not to mention, it can be confusing what the delivery timelines are and everything that goes into play and how they affect your transaction. So we figured we'd do exactly that. We'd break it all down from both sides, both from the legal side and from a surveyor himself. So today we have Sterling Law with us and Canoy Surveying. Thank you guys so much for being here today.
I'm happy to be here.
We're very excited.
Tell us what you got. What do we need to know?
If it's okay, Adam, I can kind of start and then I'll hand it off to you. Does that work?
That works great.
Awesome. So I love what Kate kind of said regarding surveys being harder for you guys to get the client to wrap their head around. The way I phrase it a lot when people call me and want to know my opinion if they should order a survey is the answer is always yes. I think of the survey as the land inspection. You're not going to forgo a home inspection. So you're buying both the home and the land. So don't you want to know what's going on with your land? So trying to phrase it in a way that they can wrap their head around, digesting essentially the added expense that the survey brings when they're already thinking of all the things that they're spending money on when buying their property. Um, but the survey is very important because of a lot of the things that have been brought up. We want to know what's going on at the land. GIS is notoriously wrong when it comes to what the boundary lines of the property are. I think my personal house shows my house on my neighbor's lot, to be quite honest, on GIS. And I know that not to be true because I got a survey done when I bought my house, as a prudent home buyer would. Um, the survey will show a lot of things that you want to know, especially with when we were in our COVID bubble and everybody was doing things to their property. They were adding a lot of beautiful hardscapes that we love to look at, but people forget. And we're getting and doing things DIY, especially adding all that concrete to their property and not realizing they were going over in the impervious surface. The only way to know if you're over on the impervious is to get a survey. And that's something that you want to kind of to speak to your clients about as well, especially if they're looking at properties and they have these beautiful hardscapes in the back. Even more reason to get a survey to verify everything is good. We had a little kind of breakdown of a few things that were in my purview, in my lane, and then what's more in Adam's lane that he can speak to. But when it comes to how surveys, basically, we start at the beginning. How are they ordered? Every attorney tends to do it a little bit differently, and every agent does it a little bit differently. We tend to At Sterling Law, what we do is we provide a list of potential referrals for surveys, and then we let the client price shop because the survey is going to be not the same. They're not going to be the same price from every surveyor. So you can price shop it, and then you, as the client and or the agent on behalf of the client, initiate that request to get the survey going. Because essentially the client is the one who should be on the hook for ordering the survey and being on the hook for paying the survey. So it needs to come directly from them to the surveyor. I love the way Adam does it with his company, because they're everybody does it differently. I will speak highly of Adam in that regard on how he handles the survey ordering. It makes me happy. But the typical price range, it varies. It could be, you might think just for a small quarter-acre lot, it would be around 600, but it could be a lot that has a lot going on, missing pins, make it very difficult to survey. So every survey is specific to that lot. So there's no just what's the average price. I would never advise you to tell your clients an average price. I would say, let's get a specific price for this property, and then we could price shop it with a couple different surveyors in town to make sure that we're getting what we want and getting all of the things like the impervious surface calculations, everything that we need. And then the last thing I'll kind of touch on before I'll hand it off to Adam is really when we talk about turnaround times, and when we need the survey back. We know our DD periods tend to be about 10 to 14 days, sometimes even less. Surveys survive due diligence. You do not need the survey back during the due diligence period because survey issues are title issues, and title issues survive due diligence. So if you get the survey back outside of due diligence and there is a title issue, the seller still has to fix that and remedy that issue in order to convey clear, marketable, insurable title to the buyer. So it's not something that you have to pay for a rush or get it back. I know there's a lot of clients that will want it back during the due diligence period, which it is their prerogative, but it is something to explain to them that if there is an issue that appears on a survey, that would be detrimental to title, meaning the house is over the property line. Their accessory structures are off the property line. The impervious surface calculations are vastly over what's allowable in that county or municipality. All of those things are title issues that the seller has to fix. So it would be something not like a home inspection when you find an issue in the home inspection that it's discretionary if the seller does anything. They actually, as is contracts, they don't have to do anything. Surveys are different. Surveys, they have to fix what's found on it. So getting it back as soon as possible is great, but a lot of surveyors, I can let Adam speak to his own turnaround time, but generally speaking, we see most surveys 2 to 3 week turnaround time is pretty average. So trying to get it back in 1 week, you're gonna have a hard time finding someone who can do it. And then if you can find someone who can do it, they're probably going to charge you an expedite fee in order to get it back that quickly. If there's any questions as we go, please feel free to stop me. I talk fast and I am long-winded. So I understand both of those things, but I will let Adam speak more specifically on surveying and the more nuances of things and everything that's in his lane. And if you need me, I am here.
Gosh, Cara, you just covered everything already. I know you're speaking fast so you can save the clients a little money. So she did cover a lot there, and I would say everything she said was right on point. Um, and as we're going through this, we'll actually touch on some of the stuff she was going over as well. But to start off with, I just kind of want to define who we are and what we do. As land surveyors, we're expert measurers. We don't make legal determinations, which is why you'll see, at least on our surveys, we don't call anything an encroachment. We're not going to use that word, and we're specifically doing it for a reason. We're going to show that the fence appears to go over the line onto such and such property a certain distance. That's a statement of fact as accurately as we can make it. So then the attorney can look at it and decide if it's an issue. The real estate agent can look at it and decide if it's an issue with your client. And the other part of it is a lot of what dictates what an encroachment is and isn't is who built the fence. We can't really determine that, right? So between the other parties, you kind of have to get together and decide that. But an encroachment is also more a legal term. We can show if it goes over the line, but I'm not going to say something's an encroachment because there's a lot more that goes into what defines a boundary than just what I'm showing on a survey from a legal standpoint. Typically, it's pretty straightforward, but when you see really bad issues, then it really becomes more the attorney issue because you get into junior senior rights and all kinds of things that start to forego what a land surveyor, at least me as a land surveyor, would be comfortable deciding. So, the tasks that we are providing on a daily basis are lot surveys. That's mainly what we're probably going to go over here today. But we also do things like subdivisions. We do site plans and plot plans. We do marking a line so somebody can put in a fence. We do impervious calculations as Cara referred to earlier. Stream locations. I wrote stream locations, but I want to be clear on this. We can't determine what is and is not a stream. That has to be done by an environmental engineer. But what we do is locate the top of bank if it's blatantly obvious. And then we'll show that on the survey as well, because in our area, buffers tend to apply to streams. So on some of our stuff, you might see, possible stream buffers may apply. That may mean that, we saw something that looked like a ditch or a stream, but again, we're not environmental engineers. We are giving you a heads up that there might be a buffer. Do know typically that's not going to affect something that's already in place as much as it will if your client wants to do additions or add an ADU or something like that. It becomes more cumbersome, or in some cases not possible to build in those buffer areas. So if they're looking to do expansion of any kind, that's when you're going to want to make sure that you get a survey done if it looks like even there's a ditch. You and I might look at it and say that's a ditch. An environmental engineer might look at that and say, no, that classifies as a stream. And it has to do with vegetation lines and certain types of vegetation. It goes a little bit above my head, which is why we don't define them. But if we shoot the top of bank, typically that's going to be on the safe side of where that buffer is. If anything, it might be a little bit less if you get a true determination done. But do know you'll see on all our surveys and all good surveyors will do this as well. Our general note specifically says that our survey doesn't include environmental items. That's because even though we're showing the top of banks that are obvious to us, if a environmental engineer comes back behind us and says that, no, I consider this a stream and we didn't even notice it as a stream or a wetland, then that is something that might pop up from an environmental engineer. Again, not something you're going to have to worry about as far as a house you're buying typically, but it is something where if you're in a low-lying area and your client is really intent on building more, you might want to bring that up to them if they want to get a wetland and stream determination done. Unfortunately, those things take time though. So typically that's going to be a client that is some form of infill developer who will be doing that, and the due diligence and even closing time would need to be extended most likely if they're trying to get that done before closing. So we typically deal with real estate agents, attorneys, engineers, architects. On a daily basis, we're kicking out lot surveys for closings like this. But we're also dealing with engineers and architects on major subdivisions and infill type subdivisions. So if you've dealt with any of those small house lots in Durham, we do a lot of those, along with ADUs and additions to houses. So that's typically where we're dealing with the infill type stuff. All right, can you go to the next slide? So I know a big question we had was typical pricing. And as Kara said, I'm not going to say that anything's typical necessarily, but this will at least give you a little bit of a go-to. If something's super straightforward, our lowest point is 675, right? That's to get our guys out there, do the work and get it mapped. We can't do it for less than that. So lots of these that are coming through, if they're in a subdivision that's 1990s or after and half an acre or less, are probably going to fall in that. Now, if we look at it and it's got a ton of impervious that we've got to shoot, that price might go up. Or if it's in downtown Durham in a notoriously bad neighborhood, not safety wise, but like property wise, there's several bad spots in Durham where the plats don't match up to the irons. So now we've got to go figure that out. That's going to add extra time. You might see it increase past that 675, even though it's a half acre or less, because it's going to be an older plat. The $750 to $1,300 range, that's typically going to be your 2 acres and pretty easy, or it's going to be even your half acre, but really hard, right? It's going to be somewhere in that range. Once you get over 2 acres, you'll see I don't even have a price on that. And I'm actually saying even an acre. I would recommend just saying, nope, we're getting a price. I don't even want to give you any form of range on this because it can vary so widely. With our pricing, I think what you guys have seen is that once we price it, we're going to do it for that price on these lot closings. That's not necessarily the standard, and there's nothing wrong with doing contingent pricing. Just understand when you're getting pricing from surveyors, be very specific about your scope and be very specific about if you're having problems out there, is there a certain amount of hours you're going to spend on it before we got to revisit pricing. Again, nothing wrong with that, and I get why people would do it. It helps protect them. For us, we kind of take the approach of we're giving you a lump sum price. We're going to win some and lose some, so to speak. So I do know some are going to be more difficult and some are going to be easier, but this is our lump sum price, so y'all can go ahead and plan. Other surveyors will take a different approach where they'll give you a certain amount, but they might be contingent. This is assuming we can get the field work done in 4 hours. If we're running into issues, we'll give you a call and say, hey, we think it's going to take another 2 hours. Can you release us to continue on? That's not terribly abnormal. That's just not our model. It's a lot to keep up with, frankly, and it's just easier to go lump sum for me. But if you're working with a one-man band type, you'll see that a bit more.
Adam, I have a few questions about pricing real quick before you move on.
Yeah.
I'm curious, how do you do pricing? Is it just based on the GIS or are you actually going out to the property? Like, how are you crossing your bases to make sure like what you're giving is accurate? Is it
Excellent
based on
question.
size?
Excellent question. And you hit the nail on the head. Once I get the address, and that's why if there isn't an address, I'm going to ask you for the PIN, REID, something I can look up on GIS. We're going to look it up on GIS. We're going to check the most recent plat, and we're also going to turn on the aerial imagery to get an idea of what's out there. We might even go onto Google Maps or Zillow or something like that and scroll through a couple pictures to make sure that, it is a typical house that's going to fall in this price range. But that's part of how we're able to do the lump sum because I have somewhat of an idea when we put a price on it.
Got it. And then this question is both for you and Kara. Like we mentioned on the front end, often it's the attorney that will order the survey, but if you guys recommend that we shop prices, Kara, are you guys shopping the prices and giving us options specific to that property, or are you recommending that we as the agent shop it?
Yeah, so the way our portal works is once we open the contract, there's a little button in our intake portal that says order a survey. And either you or the client can click on that button. Once you click on that button, it'll list out like 5 or 6 recommendations, and it gives the email address and the phone number for 5 or 6 of those surveyor recommendations. And that's when you can then contact those different ones. We don't do the price shopping because it we want to cut out the middleman. If I have to call back and forth, like, well, this guy said 500, this guy said 600, like it just tends to be like a pain in the butt. So we let the buyer, if they're really nitpicky on pricing or timeline, or they also might have specific needs that we're unaware of. Their goal is to build a pool after closing or something. So like when they're calling the surveyors and getting those pricings, they might be like, I also want flags every 200 feet, like something silly. And if that's the case, or I need to be physically present during the surveying, all of those needs can be specifically mentioned to whoever they're getting the pricing from. And then they're the ones who initiate that, like pull the trigger, like, yes, I now want to hire you to do my survey and everything. And we get notification of that. So when the plat comes back, we can review it and go over it with the client. But the actual pulling of the trigger and saying, I want to hire you is done by the client buying through you guys as agents or just directly from the client themselves.
Got it. That's what I needed to know. Thank you. And then Carrie put a question in the chat, which is one I had. It's about townhomes and surveys. Is that something you're going to hit on in a little bit?
I don't know that I covered that specifically, but typically that is going to fall in the 675. And what I'll say about those townhomes surveys is lots of times people forego them. If I'm being honest, I see as many problems with them, possibly more than I do on lot surveys. And usually it has to do with fences or something else where maybe somebody built into the common area. Might not be the end of the world, but it is something where if you're getting a home inspection done, even on townhomes, I recommend surveys. A lot of people think, well, this is what I got with a townhouse. Fair enough, but just understand there can be property issues with townhomes as well.
Is
Um,
it true that if you order a survey for a townhome, they have to survey the whole building?
Lots of times we have to go chase irons for the whole building to find out where our piece is. Yes and no. There's two different ways of doing it. You can survey around the whole building to make sure that it does what's called closes, to make sure that you got it accurate, or you can measure certain parts of the buildings and then you hard measure between those and make sure they match up. That's typically what we do. We've done it both ways, but it is more than just surveying your one unit. There's more involved typically with a
Okay.
uh,
Yeah,
town.
I'd heard it that you'd have to have the whole building surveyed and then therefore it could be almost more expensive than a regular survey, and I just wasn't sure if that was true.
Sometimes they're actually more difficult because they don't monument those as good. So, I mean, I'm taking a risk at 675 sometimes when I do that because if they didn't, then I have to go all the way out to the external boundary, which can be thousands of feet before we even start our survey, just to measure in those points.
Got it.
Um, but honestly, that's part of what creates the issues too, because sometimes it doesn't necessarily line up with the common wall, and then it becomes, do you hold the measurements or the common wall? I think you hold the common wall, but that's more a Cara question when it gets into that. Something that Cara did touch on though was scope. And I don't think I addressed that in here. With us, you'll see that we send over a survey agreement that has our specific scope that we're going to cover. So things like marking out the property line every 50 feet, that's not covered in our typical scope, but it is something we can do additional. No matter what surveyor you're using, if they don't have a scope set, ask them for one and just consider that it's not being done if it's not specifically mentioned in that scope set. Um, all right. I
I
guess we can.
agree with that wholeheartedly. The one other thing I want to mention is, especially when it comes to impervious surface calculations, make sure that is being asked if that's something that you are looking for. And I highly recommend you are, because you could find a surveyor who might be doing it for 500, but they're not even sometimes showing where the house is. I get a survey back and it just shows the boundary lines. I was like, well, where's the house? And they're like, you didn't ask for it. And I'm like, bitch, no, yes, I want all of it. Like, so you just got to be careful. Like, you get what you pay for sometimes. So make sure when you are price shopping, if it is a client that is looking for the cheapest in town, you get what you pay for.
And will you guys just define impervious surface? I know most of us know what it is, but just for the sake of this video, and if someone doesn't know.
Yeah, actually go to the next slide and that'll be on there. But to Kara's point, if you order a boundary survey, it could just be a boundary survey. So if you want specific items, make sure you ask for them specifically. Because that's how we price the surveyors, right? If you want less, we can do less for a cheaper price, but you're going to get less. And depending on who you are, you might price the cheapest thing and just hope they don't ask for the scope. There's different types of survey, right? So that's what defines scope. With what you guys are doing, typically you're going to be asking for a typical lot or a typical closing survey. That's fairly standard nomenclature in the survey world. But there are other types like topographic and subdivision. If you're working with clients that are either trying to break into infill development or even major subdivisions, then they're going to want to know about those other two items as well. But if you're just working with a client that's buying a house, they're going to want their typical lot survey. Uh, you're always going to want to say when you need the survey back. As Cara mentioned, if you're trying to get it back before due diligence with us, it's almost always going to come with an expedite fee because of how quick you need it. We're typically about 3 to 4 weeks out. Sometimes we can get 2 to 3. But when we're getting 2 weeks out, that's when we're getting into our expedite fee timeline. 3 weeks out, we can usually hold standard pricing, especially during busy times. January, February, we're a little bit slower, so sometimes we can turn around something quicker without an expedite fee. But during the summer, it's definitely going to be an expedite fee. The impervious surfaces. So what that is it's any concrete, stone, house, anything that doesn't allow water to penetrate into the ground. The thing about impervious surfaces is it's different in different municipalities. So there's no standard set rule. Even CAMA has different standard set rules than a lot of these municipalities. So for example, down at the coast, CAMA considers 57 stone, which is clean. It doesn't have dust in it. So it allows water to penetrate through it. It's what they use in dams to allow water to flow without messing up dirt. That's considered pervious by CAMA themselves, but Durham County will not consider that pervious. So if you're getting close on your impervious and you want to use gravel driveway as an pervious surface, they won't allow that. They also make pervious, what are they called? Like concrete pavers, but they're pervious. That's allowed in a lot of municipalities. Again, it's not allowed in Durham. Decks are different in different municipalities. So what you'll see on our surveys is we'll survey everything that could be considered an impervious surface, and then we'll layer it so that depending on which municipality you're in, if they say actually that doesn't count against your impervious here, you can cross it out, redo the math. and you've got all the information you need right there. We try to put the impervious surface limits on all our surveys. If they're readily available and we know them, they're going to be on there. If they're in a municipality where we haven't been able to confirm yet, whether they haven't called us back or we haven't found it in their UDO or it's not listed on the plat, then we'll just have the impervious surface that we've calculated, but we won't have the limit. And we should be having a general note there that says contact such and such to verify an impervious surface limit. So do know we do try to find that for you. Sometimes we do, sometimes we don't. When we don't, we'll say contact such and such just to verify. But you will have the calculations there so that you can make sure. I do a lot of infill development. So I can tell you, I usually don't see impervious surfaces being terrible as far as having to rip out what you've already got there during a lot survey. But if you go to build something, that's the first thing they're going to ask. So if your client wants to add anything, a pool, an addition, a deck, anything, and they're going to properly get it permitted, that's going to be the first thing they ask for. And if they're over, they're not going to let them do it. So that's a big part of the risk. I have heard horror stories about them telling them they've got to rip out impervious surfaces on the back end as well. I just personally haven't been a part of that, but I have heard about that existing. So that's another reason you might want to get it done before you buy the lot. Uh, all right, next slide. So another one is easements and title searches. Know that we do our own independent search on the property, but I'm never going to guarantee that we're as good as getting a title search done, right? So I'm always going to encourage you, hey, get the title search done. If we find something during our search, we're going to show it if it's showable. But you're going to have a title search done during this process. Have a quick look at the title search. Make sure there's nothing in there that maybe we didn't see. If there is, if you see an easement and you don't see it on our survey, then call us up and ask us about it so that we can get it added if it is possible to get it added. Again, we try to find it so that we don't have to go through that, but do know it's worth doing a little bit of extra due diligence on your end just to make sure that nothing falls through the cracks. Because we all do make mistakes. We try to make as little as possible and do everything perfect, but none of us are perfect. Once we have easements, we'll show them on the property as long as they're tied to the property in some way. What you'll find is as you get better at reading through easement documents is there's a lot of what's called blanket easements. So it might say that it follows the underground utility and it's, 15 feet wide centered on the underground utility. Well, there's no way for us to know where that underground utility runs in the property unless we do fairly extensive work and call in somebody that does underground utility location, which is going to take too much time and it's going to cost a lot anyway. So they're generally considered blanket. So on those, you won't see that on the survey because there's no way for us to physically locate it on the ground to show it on the survey. Lots of times those are going to deal with like underground power, cable, stuff like that, which can move anyway. Say they come in and they make it fixed to the cable line, they're not necessarily going to bury it right back in that same spot. So it's actually going to move on the property as time goes by anyway. But it's generally intended for that. But something that's like a sewer easement that ties it to the property and is shown on the plat, we're going to show that so that you see it on your property in relation to the other items that we're showing. And I think one of the questions was on red flags. The red flags on like buying a house, I would say anytime you see a fence that specifically wasn't shown on a very recent survey, I would say go ahead and get a survey done. Much to what Kara said, it's like getting a home inspection, but for your property. Really, what you're trying to prevent when you get the survey done is any headaches down the line. So if something pops up on this survey, you want to address it now instead of it costing your client money later.
That's a really good point. I think a lot of people think, oh, there's already a fence. I don't need a survey. I think it's almost the opposite of that. Obviously, if you're going to build a fence, you need one because you're going to need one for a permit anyway and to get HOA approval, all the things. But if there's already a fence out there, it is almost more important in that respect to get one. And I say that because I see fence encroachments all the time. Like, I mean, the likelihood of it being actually built properly is probably 50-50, to be quite honest with you. And there's going to be times when you might see, Adam will report that the fence is over the line by 0.7. It tied into another neighbor's fence or whatever, and then it created a couple inches encroachments here or there. That's not something to be concerned about. And specifically, our contracts don't allot for us to say that that's a material breach of contract or a material title defect to where we have to force the seller to fix it, because a lot of times when you see fences tie in, which creating a couple inches encroachment here or there at corners, that's because the HOA required fences to be put up like that to look more uniform and to not have parallel fencing that nobody maintains in between. So when you see those little tie-ins, that's not something that I'm gonna throw a fit over. And we can't actually anymore because the contract was revised about 2 years ago to not allow us to be able to cause a fit over that anymore. Well, I'm gonna cause a fit when we have a few feet of fencing, even into HOA open space or something. These are situations where you need to be aware of this. What do we want to do? Because the buyer is going to have a few options. They can demand removal of the fence that is on the neighboring property. They can ask for an encroachment agreement to allow it to stay. There's just a bunch of options that we're going to have, but you won't even know what those options are if you didn't get a survey to find out what they were. And now it's not coming out of your client's pocket. It's coming out of potentially the seller's pocket because we discovered these matters that are title defects by getting a survey done. I'd also say that if we have an old survey, the seller provided you a survey, you want to look at that. 9 times out of 10, that survey is not going to be useful to get the client title coverage. But that survey will be useful to know what's there. It's that peace of mind. It's that knowledge that you want as a home buyer. If any work has been done to the property since that survey was completed, maybe the seller added the fence at that point or added an accessory dwelling unit or added a deck, get a new survey because we don't know if those things were put in properly. But if the seller provided you a survey, nothing has changed since that was done. It was done 5 years ago, but nothing has changed. Not even a neighbor hasn't even added a fence, because you got to think about that too. Not just what you have done to the property, what have your neighbors done, which could cause issues to your property lines. Then that could be a situation where if the client is very much nickel and diming and worried about funds, that could be a time where you could forgo getting one. But be careful what you're given when you're given something from the previous owner and what you're being provided, and if it's going to be useful or not. I did see a question. What about trees on the property line? Who controls them? That's such a good question when it comes to that kind of thing, because a lot of times trees are wider than the property line. And when it comes to who owns what, it's a matter of sometimes what the insurance company is going to deem who's in charge of it. Because if the roots are over here and the tree is over here, how does that impact things? We worry mostly what happens if the tree starts to die and falls or needs to be torn down. Who has the authority to go and tear it down or trim it or all the things? It's very nuanced. So unless you get like a specific question, I don't want to kind of give you like hard and fast rules, because as a lawyer, everything depends. It depends on this, it depends on that. So I can't tell you specifically, but I can say that it does depend. Think about where the roots are, think about where the tree is sitting, and situationally what your concern will be regarding that tree. Are you worried that if it dies, who tears it down, or if I need it trimmed, if I'm allowed to do that? bring those questions up in specific situations and just say to your client, that's a great question. Let's get the specific answer from the attorney if they have that kind of issue when they're out there looking. Adam can speak to whether or not he's going to put a tree on a survey. I very, very rarely see trees, bushes, things like that on surveys, but I'll let Adam kind of explain why that is.
That's correct. We're not going to show a tree unless we're considering it a corner. So if a property corner falls in the tree, or if it's called for the tree to be a corner, we will show it then. Now, if we're specifically asked to show trees, we'll do that. Getting back to that infill development type stuff, sometimes municipalities want to see that when you're building. So we can show that on surveys, but that's definitely not a standard thing for us to show. And to Kara's point on the fence being 0.3 over, not being the end of the world, it's a relief to hear an attorney say that, and it's one of the many reasons we like working with Cara. But do understand our equipment, I consider it only accurate to within 2/10 of a foot. Now it is more accurate than that, but when I'm surveying a fence, if it's showing 2/10 over a line, I'm not even going to show that as crossing a line because there are some inaccuracies in our measurement before you even get into human error. So effectively at that point, I consider it on line. But when it's 0.3 over, it's pretty apparent that they were shooting for the right thing and then that somebody else tied into them, or one fence was built first and then the next guy just tied into it. 0.3 feet is 4 inches. By the time you add in the 4x4 post and the width of the fence, we're starting to get into a gray area of where is the line we're talking about. So though we are going to show it if it's over 2/10, the reason we do that is for it to be abundantly clear that we're doing our job, one, but two, so that you guys can discuss and decide whether it's not something to worry about or not. So if you guys are working with clients that are trying to do some form of infill development, another couple red flags would be ditches, manholes, utilities. Definitely if you see manholes and for some reason it's not showing on our survey, that would be a red flag. That would be a red flag on if you had an old survey and then all of a sudden there's some manholes. A manhole is going to be a clear indicator that most likely an easement exists. Now, sometimes it can be a septic tank, but that's very rare. Usually a septic tank's not going to look like a manhole. Ditches are another one. Ditches can be a sign of a stormwater drain. Specifically, if you're getting into like downtown Durham, they're kind of notorious about having storm drainage that was never properly easemented. So a party was never compensated for putting in this drainage system. So now there was no easement that was ever recorded, but they're starting to use it as a municipal stormwater control measure. Typically, when that happens, even though we're not able to find an easement and sometimes they don't even exist, they're going to try to claim that as eminent domain. I don't know the legalities of that, but I can tell you that every client that I've brought it up to has said even if it's not technically legal, they ain't going to fight it because it's not worth the money on an infill lot. So if you see ditches and they're looking to build something on it in the future, that's a red flag where we need to get it surveyed and see how Durham would approach it. And that's not just Durham, that's other municipalities as well. But Durham's just the biggest offender that we see on that. All right.
One other thing I want to red flag, I'll just tell you a little horror story. It's Halloween. Well, let's get a horror story. So one of the ones that I recently handled is, I'm not sure if you guys are familiar with McLaren Farm. It's in Fuquay. They're pretty large lots and they're all new construction. It's pretty higher end homes as well. So when they went, she got the initial like measurements done and everything. They very extended driveways, beautiful things, lots of hardscape and lots of things out there during the construction period. They knew they were going to be tight on impervious. Thankfully, this buyer got their own independent survey done because I don't know what was going on with the county getting the CO and getting the as-built and everything, but the measurements were vastly off from the initial measurements on what was going to be built, what ended up being built. and what that guy measured and then what our independent survey measured. 700 square feet off, a large amount of concrete. So much so that the town of Fuquay has very strict rules right now regarding impervious. Like it's like no nonsense, very strict rules. So much so that my client had to buy impervious from a neighboring lot that hadn't been finished being built yet, and a new plat recorded exchanging impervious prior to closing. So I'm telling you all of this to say, when you have new construction clients asking if they need a survey, and they're in their mind going, why would I need a survey if it's new construction? Get one. Most of the time, the builder is going to provide you one for a lesser sum because they should be getting one done, or most of the time need one to get their COs. So make sure you ask, and if the builder is not getting one, get one done, because you want to make sure that, especially things like the impervious, you're not walking into a problem when the house was and you build it from the ground up.
We've also seen new construction not quite fall in the right spot too, so that's a great point as well. If they're not providing you with one, go ahead and get one done, just to make sure everything's where it was supposed to be.
We have a hand raised real quick. I have a question after you. Cindy, what you got?
Hey, thanks so much for doing this. I'd love your contact info at the end if it's on the slides, or if you could share it in the chat. So my question is, with impervious surface, to me, that's like such a permanent word. So, what happens if it's over and the seller is responsible for that? Do they have to, dig up a porch, or what do they have to do? What happens with that?
Well, from a surveying perspective, I can tell you if they're going to build something else, they're going to make them remove something before they can build something else. Just what I've seen in the past going through a development process. But from a legal standpoint, I got to defer that one over
Yeah,
there.
from a legal standpoint, I've seen a number of different options, but it's based on the municipality's rules and regulations. I believe there are some. I don't want to say specifically which one it is. I think it's Raleigh, City of Raleigh, or Wake County. One of them allows you to put in water retention devices, which are means of, if you're over the impervious, you can add these water basins. They can be pretty little fountains. They can be not so pretty. They range in pricing, but they'll allow you to mitigate overages impervious by doing those things. Once you do tell on yourself, essentially, that's what you're doing. You're saying, I got a survey done, I'm over. What now? And they sometimes require you to pay annual fees for them to come out to make sure your water retention devices are operating properly. It will slow down the process, because you're now slow down the process of closing. I mean, because now we're trying to get a municipality on board to give us answers and to give us these like rubber stamps on able to keep the impervious, like keep the concrete out there, by installing these measures and having them inspected prior to closing and everything. But it is a means that I've seen you not have to rip up concrete. I don't think the municipalities want you to have to do that. They're not out there trying to make your beautiful outdoor grill area go away. They're concerned, though, to make sure that the environmental measures are protected, which is what we're looking for when it comes to impervious surface.
Right.
So there are things you can do outside of just ripping it all out.
So for negotiation purposes, I've thankfully have never had this, but I know agents who have this problem. But I mean, so it is on the sellers, legally it's on the sellers.
It is legally on the seller. It's paragraph, I believe, 8H or 8G, one of the paragraphs, and it's the government compliance paragraph of the OTP. And it says in there that if something is discovered, and it's something that a lot of sellers might not know. So, but as soon as they are informed of that by you providing a survey, and they now know, they have settlement +7 to fix any governmental compliance issue. That includes impervious surface issues. So they can fix it, and then that's the part of the negotiation where you could be like, okay, well, now we're working with the government. Let's extend it another 7 days to allow you to fix it more. But it is financially on the seller. It's the seller's burden to fix it.
Thank you.
We have a
Absolutely.
few questions in the chat that I'd love to get to real quick. One of them says, once a survey is completed, does it need to be shared with the closing attorney?
Yes, it definitely needs to be shared with the closing attorney. I would encourage you to look at it as well, and I would encourage your client to look at it as well. They may have questions because they don't review them regularly, but that's part of why you want to send it off to the attorney.
Yeah, and the attorney
Our process is when if we get it, most of the time we get it, especially if you ordered it by like pressing that button in our portal and stuff. I review it, and then it'll come from Courtney, my paralegal. It'll come from her, and it'll say, Cara looked at this, no issues, great, great. Or Cara looked at this, and most of the time you'll get it directly from me. Courtney won't be like, Cara looked at it, it's a hot mess. I'll reach out and be like, it's a hot mess. Here's all the things we need to fix prior to closing, or what have you. You'll hear directly from me. But if I wasn't included, or my office wasn't included when it came back, you independently ordered the survey or whatever that happens. I also need to see it because I need to provide it with your final title, because I want you to have survey coverage on your final title policy. So I need a copy of it in order to do that. And I also, if you want the surveyor paid at closing, I need the invoice to collect on the settlement statement.
Perfect. Thank you. Kelly asked, as agents, we are trying to guide our clients about a home and property well before ordering/reviewing a survey. How much can we or should we review on public plat maps, i.e. for easements, impervious surface, etc.?
Well, some of that stuff you really need a survey for, like the impervious surfaces, even the easements. It'll show a basic location, but as Kara said earlier, GIS is very basic. It's worth reviewing before you even start the process. As an example, the house I ended up buying, there was a property line running right down the middle of it. So we immediately knew we had to get a survey, but that allowed us to get ahead of the game. What happened there was they had done a recombination, but they never actually properly recorded it and deeded it over. So during the process of our closing, they had to do that. But things like that, GIS is, I hesitate to even say good for on GIS. It's worth looking at. I just wouldn't put a whole lot of weight into it.
Yeah, and that was one of the questions that I'd had earlier. Not to catastrophize, but I know it's a rare situation, but I was curious what would happen if you are in one of those scenarios, whether it's a regular property or a townhome, if the building itself is over the property line.
It slows
Yeah,
down
it's super
closing.
fun. I've had it happen a few
that. Yeah.
times. Yeah, I unfortunately have had it happen a few times. It tends to, you got to do what's called cross deeds. It's a whole nasty mess. Everybody, I mean, I had it. I want to think they're called the Gateway Townhomes in Briar Creek. They were all built off the property line, and it was like the whole strip of townhomes. Every single one of them was off the property line. So when people ask me, I am getting a townhome, should I get a survey? I'm like, please do. Cause I honestly, please do, or please don't. Cause I don't want to run into this again. So it's like that, like trigger word, but I've seen it where the whole thing, and every single person on that street had to deed over to each other. The plot had to be redone. It can be fixed. It just takes time. And then I find it where people like to shoot the messenger. Like, I created the problem. I'm like, first off, I didn't build the house off the property line. I'm just reporting the news. And that's kind of what you hired us to do, is report the news to you. And some people don't like the news, and then closing's delayed, and it's a whole mess. But that does tend to be the worst case scenario, is when people hear that, what's the worst thing we could find on a survey? And we're like, well, that your house isn't on your property lines.
Well, we'll try not to manifest that for anyone. Mary, you have a question. What you got?
Yes, thank you. I have a client who's under contract to build a home on a given lot, and that lot has to accommodate a pool, but it also a well and a septic. So we're getting the septic lines redrawn by the engineer as we speak. But I had noticed on the plat, it says apparent deed overlap towards the back of the property line. And now when I just asked the attorney about it, and the house, we didn't even break ground yet for the house. We're very early on, but my client has already, remitted deposits, et cetera. And so they're being very dismissive and saying, well, we don't do any of that until 30 days before closing. But how concerned should I be, and how should I advise my client about something that says apparent deed overlap and no one wants to address it at this point in time?
What that means is that there are two different deeds that are showing the meets and bounds for that particular piece of land as being owned by that individual. So deed overlap means there's more than one deed showing that land, and they're differing owners. A gap means there's a piece of land that they can't find a deed that shows that piece of land. Gaps are less concerning. Overlaps are more concerning. I hope, yeah. I would want to know that closer to I would want it to be looked at sooner than 30 days, because an overlap could take longer than 30 days to fix. It could be a title defect. It is a title defect. To look into a little bit deeper, just to make sure that that it is resolved. Because essentially to resolve an overlap, somebody has to declare the rightful ownership. So
exactly, which is why I want them to look at it now, but they're kind of brushing me off, and it's a builder. So it's not as if I can choose the closing attorney. It kind of is what it is. So now we're going to have to kind of play hardball with them, because from the very beginning, I kept bringing this up, and everyone else, they're sort of minimizing it and dismissing it like it's not a thing. And I know it's a thing. That's why I'm listening to this class right now, just for that reason.
I'm sorry you're going through that. I think you're advocating really properly for your client right now, and I would press just keep pressing the issue. Definitely tell your client it has to be resolved. So it's not something, even if they decide not to look at it for 30 days before closing, which is a weird thing to say, it still is going to have to be resolved. But I know that might not give them that peace of mind, but that it's now fixed. But to continue to advocate and push for your client is what you want to do. Your client shouldn't have to pay another attorney to fix this, when essentially, if you're utilizing the builder's preferred attorney, that attorney represents your client as well, and should be fixing it for you.
Yeah. And it's just very difficult if they flat out refuse. I don't know how I'm going to handle it, but thank you for all that input. I appreciate it. At least I have clarification of that, my thought was correct. And I do need to look out for her in this case. So thanks.
Absolutely. One other thing, what Kelly had said, like, what can we look at as agents ahead of time and everything? The recorded plat is important. So if you look at the deed reference, like the current deed, you'll see the plat reference in the legal description. When you pull the current plat, there's especially if they're newer subdivisions, especially in municipalities like Holly Springs and Apex, they typically on the lot put the amount of impervious on there. I know for certain they're doing it in Holly Springs. So what you can see on that is if it says like 30% impervious, you have a frame of reference at that point where you're looking now, like, it's a 30%, but you also know this house has like no grass. It's all concrete in the back. You're like, wait a minute. So like you can trigger questions that you can then reach out to the listing agent and be like, did you get all that permitted? When did they install that? This looks like a lot of concrete out there. So even before you put in the offer, you can have those kind of questions and that spidey sense. Like, I pulled the plat before I wrote the offer. It says 30%. Like, and it just makes you a better agent. Like it's just like making you guys look real cool to your client before you even under contract.
Yes, we've been investigating this in an in-depth way with the listing agent because of the fact that my client wants a pool. So, and he's been wonderful. It's so I'm just going to keep pursuing this. Thanks so much.
Thanks, Jill. All right, Adam, back to you.
Any other questions?
Um, I think we kind of already went over should I use an old survey, but just to recap real quick, if you've got an old survey, there's nothing wrong with using it. Just make sure it's relatively recent. And as Kara said, I totally agree. What you really want to do is look at that survey, look at your property, make sure nothing's changed. If something's changed, that should trigger you to want to get it done. And just because nothing's changed doesn't necessarily mean you don't want a survey. But if everything looks the same, it's a recent survey. We are held to board standards, so it's going to be very rare that you would ever see a surveyor like pull a quick one. That's not how we work because we lose our licenses. So um, I think that covers that. I got a couple more slides, but I know we're getting low on time. So maybe we skip to that second to last one. Let's see. Oh, this is a good one too. And then we'll go to the next one. So I think this one showed, I guess it's a little hard to read there. But we got drainage easements around the outside. That's what that dashed line is. And then on this one, we have a 50-foot riparian buffer. Now, this is an example of where uh, we weren't able to define where the top of bank was, but it was shown on GIS as a stream. So we scaled it in, showed an approximate 50-foot riparian buffer, and put people on notice that, this is approximate. But do know if you want to build or anything like that, one, you're going to want to define this, but two, it does look like the buffer's going to impact your buildable area. Now that line around the outside, that's just showing you your drainage easement there. And the impervious table on this is on the left. It's zoomed out a little bit too much to read, but if we go to that next slide, I think it's a little bit more legible. So on this one, the general note 8 specifies that they got 65% impervious restriction, and then down there in the bottom right, it gives the impervious calculations. I don't know if there's an easy way to zoom in, but either way, it comes down to 13.48. So they've got plenty of room where they can build more stuff, but that's the kind of thing that you're going to want to look for, especially if somebody's looking to add additional dwelling unit or an addition or a pool or anything like that. And then that last slide, I'm actually going to share on my screen those couple because I can't link to it from yours. But before we pull those up, does anybody have any additional questions? No. All right, Michael, if you can drop your sharing, then I'll go ahead and share my screen. Let's see. And I just want to make sure, can everybody see my screen now? All right, very good. So to a overlap situation, this is one we're actually working with a law firm on right now. Really old deed descriptions, and we had overlapping deeds. The reason we're showing it as possible overlap, typically if we find the irons, we're going to hold the irons because monuments should hold if I can verify that they're original monuments. Unfortunately, the plat to the west, so this guy's plat, said that he set this line. So he tied in and set it. So that already verifies that it's not the original monuments. And then when you draw up the original deed and place it onto the irons that we did find, that's what creates the overlap. So now we have two different people saying that they have claims to it by description. We have one set of irons, but we confirmed that that set of irons was set by somebody after the original surveyor. So that makes it lose weight. So now we've got a possible issue. And what really triggers it is the stoops going over. There's a concrete driveway here and some other stuff, which is really what's pushing this as a bigger problem. But that's an example of an overlap that's happened and that we're currently going through. And as you can see, it's a really old plat up against a really new plat. And then one more example, this is a bigger property. This is becoming an issue because it is a developer, so he has already planned to use that land. The original survey shows that it should be what we're showing as a dark line. The overlap happened with that more recent plat. It's pretty apparent to me that that surveyor just tied into something wrong and accidentally did an overlap. I'm hoping it's not going to be a big deal because it's not really affecting anybody, but it is creating an overlap and it's holding the client up from actually being able to develop until they get this dealt with. Because what happens is Durham and a lot of these municipalities, when you go in to do your site plan, when they see this, they force your hand in fixing it before you can move forward. So if this little area wasn't a big deal to my developer, what I typically see them do is just quick claim it over because to get it really figured out costs more than what the land's worth. In this case, they actually need that land to do what they're planning to do with the property. So they've got to go through the proper steps. But a big developer that's got a really big piece of land, it's not abnormal to have these overlaps and gaps. Lots of times what I see them do is just release their rights to it and move on because it's not worth chasing out the details. But I did want to quickly go over that.
So interesting, and definitely ties right back into what Mary was just talking about.
Yeah.
Awesome. Anything else you got for us today?
I think that's all I've got. Are there any questions from anybody on here? Or? No?
Well, we'll make sure that when this recording goes out, I'll include the contact info for everyone involved so that as they come up, you guys have some resources. Obviously, Adam would be an amazing person to have as a surveyor when that time comes for each of your clients. But I appreciate both of you spending your time with us today and sharing your knowledge. There's so many little details that come up almost always in the transaction. And so it's nice to have some people to kind of bounce ideas around with and understand what's normal and what we can expect and really advocate for our clients. So thank you all for your time, and thank you to all of you agents for showing up today and as always being present with us. We appreciate you starting your day with us.
Thank you.
Thank you all. Have a good day.
Likewise, talk soon.
Thank you for the opportunity.
Of course. Bye.